Ruben Gutierrez wanted to test DNA evidence in his case after his conviction, but Texas law put up a high wall. The state said you have to prove you're innocent before you can even ask for new DNA testing. That rule wasn't about whether the test would show who did it, but about who gets to make the request in the first place. Gutierrez claimed that keeping him from asking for DNA testing without first clearing himself was unfair and broke his right to due process. He sued in federal court under a law known as Section 1983, which lets people challenge government actions that violate their rights. At first, a lower court said he couldn't bring the case because fixing the rule wouldn't change anything for him. But the Supreme Court disagreed. Justice Sotomayor's majority opinion said Gutierrez does have the right to challenge that barrier in federal court. A declaration from a judge could wipe out the rule that stopped him, giving him the chance to get the testing he's been denied. Stay tuned after the break to hear what this means for anyone who wants a fair shot at proving the facts with DNA evidence. Nine Robes uses nonpartisan, everyday language to focus on the facts of what the Supreme Court is saying. Here, you'll find clear, concise summaries of every Supreme Court opinion, stripped of legalese and clickbait headlines. Each post breaks down the facts, explains the court's reasoning, and highlights the crucial details that often go unnoticed. It's not just about what the court decided. It's about why those decisions matter. To give you a deeper understanding of the cases that define our nation's legal landscape. These summaries are generated by AI. Be careful and consult reputable sources when in doubt. In 1998, Texas prosecuted Ruben Gutierrez for capital murder in the stabbing death of Escholastica Harrison in her mobile home. The state's case relied on testimony that Gutierrez used one of two screwdrivers in the killing, and on his own statements admitting participation in a planned robbery. A jury convicted and sentenced him to death. Over the next 15 years, Gutierrez twice sought post-conviction DNA testing under Texas law, arguing that favorable results would prove he was never in the trailer. Texas courts denied his requests, ruling that the state's DNA testing law applies only to challenges to convictions, not to death eligibility, and that even favorable DNA wouldn't prove his innocence in the robbery murder. Gutierrez then sued Cameron County District Attorney Luis Saenz under federal civil rights law, claiming that Texas's DNA testing scheme denied him due process. The district court granted a declaratory judgment in his favor, but the Fifth Circuit vacated it, holding Gutierrez lacked legal standing to bring the case. Justice Sotomayor's opinion, joined by Roberts, Kagan, Kavanaugh, and Jackson, reversed the Fifth Circuit. The court reaffirmed that state-convicted prisoners have a liberty interest in post-conviction proceedings and that federal civil rights law can address state law barriers to those procedures. Following recent precedent, the court explained that a federal declaration that Texas's DNA testing law violates due process would eliminate the state prosecutor's justification for denying DNA testing, thereby removing the obstacle to testing. The court emphasized that standing analysis should focus on the complaint's challenge, not the district court's ultimate remedy. Therefore, dismissal for lack of standing was erroneous. Justice Barrett concurred in part and concurred in the judgment, agreeing that recent precedent governs and that the Fifth Circuit misapplied it. However, she cautioned against extending standing analysis by analogy to administrative law precedents, warning that such analogies might weaken standing doctrine. Justice Thomas dissented, joined by Justice Gorsuch, arguing that the 14th Amendment's Due Process Clause protects only natural liberty, freedom from physical restraint, and not state-created entitlements to post-conviction procedures. Justice Alito also dissented, joined by Justices Thomas and Gorsuch, applying a stricter redressability test. Texas courts have already determined that even favorable DNA would not negate Gutierrez's culpability or death eligibility, and a declaratory judgment would not substantially increase the likelihood of testing. Texas law allows post-conviction DNA testing only if the person requesting it can show that the evidence still exists in a testable condition, that identity was at issue during the trial, and that favorable results would probably have prevented conviction, without causing unreasonable delay. Texas courts have interpreted this framework narrowly, refusing to allow testing aimed solely at challenging death sentence eligibility, denying relief unless the person can also establish innocence of the underlying crime. The courts also limit review of new evidence in testing motions to the trial record's factual findings. This approach reflects Texas's legislative choice to reserve DNA testing primarily for challenges to wrongful convictions, rather than to reduce capital sentences for those who participated in the crime but may not have been the actual killer. Find us online at 9robes.ai. That's the number, 9robes.ai. Like and share this podcast with friends that like to be informed. 9 Robes provides AI summaries of U.S. Supreme Court cases. AI makes mistakes. People make mistakes too. We genuinely do our best to provide you with the most accurate summaries, but our best sometimes includes errors.